Hello, this is Matt on the Moon Lambo channel, and I know it's going to sound unbelievable, but it does look like there's going to be yet another delay in the SEC versus Ripple case. But I will say this, and I didn't quite feel the same about the other delays. This one, assuming it happens, doesn't bother me nearly as much for a couple reasons. First, I'll tell you here in the intro. First of all, it wouldn't be a particularly large delay, and then second of all, it ensures that expert witnesses will be able to speak, and that can be crucial. Like, because you got to understand, and you'll see as you go through this, like the implications of the people that are speaking. And I don't know who they are, but the implications of how they're responding to certain lines of questioning can result in settlement of this case. I want to make sure that this happens. And as it turns out, both the SEC and Ripple are on board. So yes, as much as we all want to get this damn thing wrapped up, I got it. In this particular case, for the first time, I'm actually not so bothered by it, even though I'd prefer this not be the case. It looks like if we're going to have all this expert testimony, whatever you want to call it, then you're going to have the delay. So I'll give you all the specifics. I also have some comments from attorney Jeremy Hogan, who of course runs the very popular YouTube channel Legal Briefs. Plenty to talk about here, but I do want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby, and just for fun, damn it. And if you don't like it, well, you can just get out. So this was shared, what's on your screen right now, was shared by a XRP community member and attorney James Filan. And here you can see, hashtag XRP community SEC versus Ripple, XRP. Parties file joint motion to extend the expert discovery deadline by 3 days to take final expert deposition. Extra time needed due to scheduling conflicts will not change other case deadlines. And so here's what it read. It's very short, so I'll just share it with you. Dear Judge Torres, and this was actually written, it's so there's agreement between the parties. So it was, I don't know for sure who read it, but it was signed by, you can see Matt Solomon, Andrew Seresny, both attorneys for Ripple, and as well as Mark Sylvester, who is with the SEC. So it's on official SEC letterhead. But anyway, just to be clear, this is a joint thing here. Dear Judge Torres, pursuant to Rule 29B of the Federal Rules of Civil Procedure and Rule 1C of this court's individual practices, Plaintiff Securities and Exchange Commission and defendants Ripple Labs, Inc., Bradley Garlinghouse, and Christian A. Larson jointly and respectfully request that the court permit the parties to conduct one expert deposition on January 19th, 2022, 3 business days after the existing close of expert discovery. Expert discovery is currently scheduled to close on January 14th, 2022. As part of that discovery, the parties have disclosed a total of 16 expert witnesses. Depositions for 15 of those 16 experts have been either completed or scheduled to occur by January 14th. However, due to conflicts in the schedules of various experts and of the counsel responsible for those depositions, the parties request leave to take one final expert deposition by agreement on January 19th. If granted, the requested relief would not impact any other deadline in the case. For these reasons, the parties respectfully request that the court grant their request to conduct an expert deposition on January 19th, 2022 for good cause shown. The parties have submitted as Exhibit A hereto a proposed order reflecting this joint request. And so that's a lot of people, a lot of expert witnesses there. So we don't know how many are on the side of the SEC and how many are on the side of Ripple, or this last one who's lagging behind, resulting in the filing of this document anyway. Don't know if it's for the SEC or for Ripple. Either way, I want justice to be done. So even if it ends up being for the SEC, here's what I have to say about that. Like, they have such a piss poor case. Like, please, SEC, bring everything that you have. I want justice to be done. I want history to show that you gave it your best go and you lost, because you're going to lose. This is not going to go well for you. and they're on the wrong side of the facts. The SEC absolutely is. So I don't care who their witness is. Like, my gosh, XRP is not a security of Ripple Labs. It's the most absurd freaking thing. The entire concept. And so, given that's the case, and given the strong case that Ripple has, that part doesn't bug me in the least. Now, here's what Attorney Jeremy Hogan had to say. 16 expert witnesses in SEC versus Ripple. That is a lot. I would say that means Ripple is not letting any issue go unexperted. Ledger tech issues, jurisdictional issues, maybe even fair notice issues will all have experts give opinions. That's definitely something, right? And then there was this. Somebody asked Jeremy Hogan the following. Jeremy, is it true that the quality of experts used and their potential testimony might induce one party or the other to settle? And Jeremy Hogan wrote the following. Absolutely. I settled my case Tuesday because the other side's expert was really good. Otherwise, I would have proceeded to trial. And so, look, that's another reason I have no problems if it pushes the deadline back a few days, whatever. Especially if it's Ripple's expert witnesses, because again, we know that they're on the right side of the facts. Like, they're on the right side of history. So yes, whatever it is, I want it to be heard. And even, like I said, even if it's for the SEC, fine. They're not on the right side of the facts anyway, so what the hell do I care? Just say what you want to say. I've said it many times before, and I mean this. I don't think that these SEC attorneys believe even a fraction of the garbage that they're claiming in this case. I really don't think they believe it. I just think they're arguing it because they're bullies. And then there was this. Somebody wrote the following to Jeremy Hogan. They are doing all 16 in the next few days, ? Or is this something that happens into 2022? And Jeremy Hogan wrote the following. They have been deposing experts the last month and will finish in mid-January. That's about 1.5 depositions a week. That's a good clip. So we'll see. Look, it's not like one of these things where it's going to push back the case necessarily for months. We've already ran into a couple of those, haven't we? So... no, I do suspect in terms of potential settlement, you're not going to see it until after this. Because I think both sides want to see the ammo of the other, including this. Also, on top of that, we want to see both sides are going to want to see it. In particular, the SEC will be curious to see if Ripple's fair notice defense is allowed to stand. And I suspect that we're not going to hear something from the judge on that until after this anyway. I don't know. Maybe we'll get surprised and it would be before all this expert witness stuff is concluded. But I suspect it would be after that. So there's still a possibility you could see settlement in January. But if it takes a long time to work out the details, it could, who knows, maybe it bleeds into February. But it's all speculation at this point. We're not completely sure. Also wanted to highlight this. This is from AMD Crypto, titled XRP Lawsuit. SEC claims all withheld documents protected under deliberative process privilege. And so a couple days or so ago, I put out a video updating what Ripple had to say on this a very recent legal filing. And now on the flip side, they're covering what the SEC had to say. And I just had a point or two to make on this, so I wanted to quickly run through a portion of this article. As the holiday season rolls around, both the SEC and Ripple are busy writing to the court. No, not Christmas cards, but letter briefs to supplement their arguments after Judge Sarah Netburn ordered them to do so. Here's what the American regulator had to say. The SEC took note of an updated reading of deliberative process privilege, which protects a company's documents related to a specific decision or decision-making process, even in the courtroom. The SEC used this interpretation to explain why the documents that Ripple wanted for an in-camera or private review should be protected. Yeah, so to pause, what we're talking about here is the SEC doesn't want to give an ounce. Like, they don't, whatever documents they have pertaining to crypto in general, really, but Bitcoin, Ethereum, XRP, and you know they're there, they don't want Ripple to see that. They don't want any of that to be public, probably because it's really damning for them. Because I think I wouldn't be surprised, it's speculation again, but I wouldn't be surprised if it shows that even they didn't know if they thought XRP was a security, which kind of ruins their case. So you can see why they'd be fighting something like this, but internally they must not have known. And so they're claiming privilege over those documents because it has to do with the deliberation process, and that's supposed to be protected, they say, and it's supposed to never be public. And so the SEC's letter by counsel Layden Stewart stated the following. Because all of the withheld documents are connected to an identified decision or decision-making process, the DPP protects them all from disclosure. Further, NRDC, that's the court case, shows that the SEC's internal communications about the content of speeches and other public-facing communications are messaging records protected by the DPP. And so here's the trouble with this, though, and they didn't address this point, which has been brought up more than one occasion by Ripple's attorneys. The SEC is claiming that all of what's been at issue here in terms of are cryptocurrencies, individual cryptocurrencies, are they securities, are they not? They're claiming that based on such sound legal precedent and law dating back to the Howey test of 1946, they're saying that was so ironclad and clear that we didn't need any special deliberations about specific cryptocurrencies. Something is or is not a security, and it's plain to see. That's the SEC's official stance. And so they haven't done any policy creation or making on cryptocurrencies. That's their stance. And so Ripple's attorneys have pointed out that's the case. But given that's the case, and there hasn't been deliberation, and they haven't been talking about specific individual cryptocurrencies, they can't then say that their internal communications are now somehow protected. They can't have it both ways. If it's clear, as they state, and it has been clear since 1946, they didn't deliberate, which means none of this is protected. So they keep trying to have it both ways. They want to state that they were deliberating and this information is protected, but they also want to state that they weren't deliberating. Do you see how piss poor their case is? That's just why I just keep saying, like, do whatever you gots to do. Like, I want as fair a fight as possible. It's just that the facts are not on your side, SEC. And the attorneys, they got to be sweating bullets behind the scenes. They know that their case is shoddy. It is crap. It is absolute garbage. They know that. They have no shame. They seriously have no shame. I'll go ahead and wrap up there because this is really grinding my gears, folks. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.